Good afternoon, everyone, and welcome to today's event, The Future of College Sports, a conversation with Senator Cory Booker and Senator Chris Murphy. My name is Zach Flagel, and I'm a 3L here at Duke Law and Director of Duke's Future of College Sports Initiative. We're super excited to have everyone be joining us today.
And hello, everyone. My name is David Duncan. I'm a second-year law student here at Duke Law. I'm a 2019 graduate of Elon University, Go Phoenix, and I'm a co-president of the Sports and Entertainment Law Society. We'll be your host for today's event.
In our audience this afternoon, it's so great to have people from over 36 states and 70 law schools or universities tuning in. David and I believe that one read on this large and diverse audience is that it's a testament to the popularity of college sports. Now, speaking only for myself as a non-college athlete, during my undergrad at the University of Georgia, go Dogs, and law school here at Duke, the college sporting experience has been central to my time on campus as a student and my emotional connection to my universities. And I'm sure that hundreds of thousands of students and alumni across the country feel the exact same way. So if we want to talk about reforming the NCAA model overall, it's going to affect not just athletes or coaches or even universities and university administrators, but it's going to affect millions of people and consumers across the country. This issue matters, and we're so excited to have two of the most senior policymakers in our country here with us today to share their thoughts.
But first, a little background on our organizations. As a co-president of the Sports and Entertainment Law Society, we have three main goals. We want to prepare students to enter those specific fields in sports and entertainment post-grad. We also want them to be able to network with attorneys in those fields. And especially relevant to today, we want to facilitate conversations on these issues within sports and entertainment that we specifically care about. This event is the second installment in the Future of College Sports series. Our first event happened in March, when we hosted a conference featuring several leading voices in the NCAA reform conversation, including ESPN college basketball analyst and Duke Law grad, Jay Bilas, Representative Mark Walker, NCAA executives Donald Remy and Stan Wilcox, and so many others. The third installment of the series will occur on Tuesday, October 13th at 12:30 p.m. We will be hosting DeMaurice Smith, the executive director of the NFL Players Association, as he gives us his unique insight from the professional sports organized labor perspective. We hope many of you will join us for that conversation as well. Now, lastly, if you're interested in getting involved with our Future of College Sports initiative, we invite you to apply to be a Future of College Sports Fellow. We welcome all members of the educational community of all academic disciplines, not just law, in all universities, not just Duke, to join our group and explore from an academic perspective the different paths to reform college sports. To apply, please send an email to futureofcollegesports@gmail.com.
Before we get going with our program, we'd like to take a moment to thank our sponsors and all those folks who made today possible. First off, we want to thank the Duke Bar Association, which is Duke Law Student Government, the Black Law Students Association here at Duke Law, Fuqua School of Business's Media and Entertainment and Sports Club, and the Student Sports Law Network. Now, for those of you who don't know, the Student Sports Law Network, or SSLN, this is their first ever event. This is an organization that was founded earlier this summer, and its goal is to bring together law students from across the country who are interested in pursuing careers in sports law. I encourage you to check out their website at studentsportslawnetwork.com for further information. I also want to give a special shout out to folks from the Duke Law admin, specifically Rachel Greason, Isabel Fox, and Miguel Bordeaux, as well as Rishi Barwani and Peter Mills from the Senate offices for working with us on their side. This event would not be the same without all of you, so thank you very much. So here's how today is going to go. First off, I'll pass the baton in a little bit to Professor Paul Hagan and Len Simon, and they're going to give us a nice little overview of NCAA reform today and how we got to where we are. I know everyone tuning in today is from, could potentially be from different backgrounds and has different knowledge levels of NCAA reform. Some of you might be tuning in because you love college sports. Others might be tuning in because you're interested to hear what Senator Booker and Senator Murphy have to say. And so to recognize this variety of backgrounds, we've asked Professor Hagan and Len Simon to give a brief overview of what the NCAA reform conversation has been up to this point, and specifically where Senator Booker and Senator Murphy fit in. After that, we'll jump straight into the conversation with Senator Booker, and then a little bit after, Senator Murphy will be joining us on the Zoom call. And then to conclude today's program, we'll have a question and answer session with 3 student athletes who are now current law school students. And so they'll be able to ask great questions from their own personal backgrounds and experiences as student athletes during undergrad. I'll now introduce Professor Paul Hagen and Len Simon, and then pass off the baton to them. Professor Paul Hagen is a professor here at Duke Law and co-director of Duke's Center for Sports Law and Policy. He's been a consultant to professional sports teams, national sports federations, national Olympic committees, universities, and professional, international, and college athletes and coaches. Further, I can't also help but mention that Professor Hagen and Senator Booker have a number of things in common. In particular, they're both grads of they're both Rhodes Scholars and graduates of the University of Oxford. They are former college athletes themselves, and Professor Hagen, like Senator Booker, is also a Yale Law School alum. I'd also like to introduce Len Simon, who will be joining us. He is of counsel of Robbins, Geller, Rudman, and Dowd in the San Diego office, and is an adjunct professor both here at Duke Law and as well as the University of San Diego Law School. In the sports realm, Len has represented leagues, teams, athletes, agents, coaches, and sporting goods companies. And in particular, on the college reform conversation, he has advised the California State Legislature in construction of SB 206, formerly known as the Fair Pay to Play Act, which I imagine, as both Len and Professor Hagen will soon discuss, really started this whole reform movement. So gentlemen, the floor is yours.
Thank you, Zach. Now, exactly 115 years ago, intercollegiate athletics in the United States faced a crisis. There was a serious decline of public confidence in the ability of colleges and universities to conduct the activity in a way consistent with the public interest, and the federal government threatened to step in and regulate it. That threat provided the impetus for the creation of the NCAA and the structure for the private regulation of this most public of cultural activities. Ironically, at the beginning of the 21st century, the organization born out of a threat from the federal government is now seeking federal protection from states and private individuals challenging its authority to regulate intercollegiate athletics and calling into question the normative basis for the amateurism principle on which that authority has been based. The crisis at the beginning of the 20th century related to the inability of institutions to limit competition in a way to make it acceptably safe. The crisis of the 21st century retains elements of that safety issue, but has been more focused on the distribution of resources generated by highly commercialized revenue sports. This distributive issue is captured in an extraordinary statistic reflecting what NCAA regulation of highly commercialized sports has wrought. In 40 of the 50 American states, the highest paid public official is a men's basketball coach or a football coach at the leading state university. While the athletes themselves are prevented by amateurism rules from directly getting a share of those revenues. The attacks on the structure of NCAA regulation have come in 2 forms. The first are antitrust lawsuits challenging the cartel-imposed rules, and second, increasingly, in state-level legislation aimed at enjoining the NCAA from preventing athletes from monetizing their athletic fame by entering into name, image, and likeness, or NIL, contracts, entering into those contracts with third parties. These challenges threaten or promise, depending on your view, to remake what the Ninth Circuit has called the revered tradition of intercollegiate sports. Now, as we introduce the current situation and current shape of the movement to reform, we're really privileged to have Professor Len Simon join us from San Diego to outline the challenges that are associated with the attempt to get through legislation or antitrust law a fairer distribution of the resources generated by commercial athletic activity. Professor Simon has been an important commentator on NIL intercollegiate related issues and was, as Zach has already said, an important participant in the Central California Legislative Initiative dealing with NIL. Professor Simon will now outline the status and background of the challenges posed by these NIL initiatives at a time when other kinds of claims are also being made on the NCAA and NCAA institutions to support various kinds of equity, health, safety, and educational opportunities for athletes. Professor Simon.
Thank you very much, Paul. Thank you, Zach and David, for inviting me. I'm always happy to support sales organizations on your campus or the one I teach in more often, 10 minutes from my front door in San Diego. And I always enjoy being back on the Duke campus, although this is not the most fun way to visit the Duke campus. Yesterday, I had the experience of watching the Padres playoff game in the person of a cardboard cutout. Also, not as much fun as being at the game. Let me try to cover 4 questions. Number 1, what is NIL? Number 2, why can't college athletes benefit from NIL? Number 3, what state law efforts have been undertaken? And number 4, just simply to throw it back to Professor Hagan as to what's up with Congress, and I'm sure he'll throw it to the good senators from there. What is NIL? It's a creature of state law. Those of you who are law students will learn it at some point in an intellectual property class if you take the right class. It's the right to your own name, image, likeness, and fame. LeBron James has the right to sell sneakers that have the name LeBron James on them, or his logo, or whatever. You don't. Because he has the right to that, he can exclusively license it to Nike or Adidas and make a lot of money. You could also, if you were famous, if you were a little famous, you could make a little money. Each of us is guaranteed by our own state laws, not federal law, varying slightly from state to state, but pretty consistent, to be the exclusive party to monetize our own name, our own likeness, and our own image. Every Duke student has this right. Every college student has this right. But the ones who are artists have it in full. The ones who are dancers have it in full. The ones who are athletes have it taken away from them. It's there and it's gone. And it's gone because college athletes are not permitted to participate in college athletics if they are not amateurs, quote unquote. And NCAA rules currently say that if you obtain 5 cents in name, image, and likeness royalties relating to your fame as an athlete or your talents as an athlete, you're not eligible. So I can explain the application of name, image, and likeness a little better to you if I use 2 examples, 2 athletes. I'm guessing everyone on the call knows one name and not the other. One is a guy named Zion Williamson who plays basketball, and one is a young man named Dylan Dethier who likes to play golf. Zion played basketball at Duke. He could have made lots of money just like LeBron, except that he couldn't. And you all know why he couldn't. He would have been a professional. He wouldn't be playing basketball at Duke. He'd be rich. He wouldn't be a college athlete. Dylan presents a little different situation. He was a pretty good golfer and a very good student in high school. He was admitted to Williams College in Williamstown, Massachusetts, a Division III school. He planned to play golf there. He took a gap year. He drove around the United States. He visited all 48 states and played one round of golf or more in every state. He wrote a book on his gap year. He made a few bucks. He went off to Williams, and for a variety of complicated reasons, including Jay Billis coming to campus and giving a lecture about how outrageous the NCAA's NIL rules were, someone raised the issue of whether he was eligible, and the NCAA determined that he was not because he had written a book about his gap year. And the NCAA's view is if you make money on something that can be deemed related to your sports name, image, and likeness, your sports talent, your sports fame, you are a professional athlete. Now, what difference does that make? Let's take it a step further. Who cares if you're a professional athlete? Well, we don't allow professional athletes to play college sports. The New England Patriots are different from the Duke Blue Devils. They're different. It's different Little League and the major leagues. They're a different competition, a different level of competition. And so the NCAA has, through a variety of rules over many decades, prohibited professionals from playing college sports. But the definition of professional changes in marginal ways, sometimes bigger ways, from year to year to year. But in the current situation, if you make any money off your name, image, and likeness, with the rarest of exceptions, you are a professional and you can't play. Hence, Zion is out of luck. No contracts, no Nike contract in his 1 year at Duke, no opportunity to monetize his enormous Instagram account. People have complained about this. People have litigated about this. The complaint is it isn't fair. It's greedy. It's only for the money. The biggest point made with Zion, and I keep talking about Zion because he was playing when this started to bubble up in 2019, is Zion generates millions of dollars for Duke, for the ACC, and for the NCAA, and Zion makes zero. That's not fair. Everyone is taking advantage of Zion. In the courts, the debate is not about fairness. The debate is about antitrust law, that the agreement among Duke and North Carolina and Kentucky and Texas and UCLA and everyone else is, we have agreed not to allow our athletes to monetize their name, image, and likeness, and we have created a price fix. We have agreed that none of us will pay more than a college scholarship for the work of the workman being Zion and his colleagues. And people have complained bitterly about the fact that college athletes cannot ask for and negotiate for salaries and cannot get name, image, and likeness. Now let me stop there and say those two are both interesting arguments about amateurism, but they're very different. If colleges allowed salaries, they would have employees working for them. The athletes would be employees. They could have unions. They could go on strike. They would be owed all kinds of benefits. If the athletes got salaries, there would be Title IX problems. Would the best player on the Duke women's basketball team need to make the same money as Zion? And how would that work? There would be internal problems at the university. How would the athletic director or the basketball coach or whoever decide what salary to pay every athlete on campus? How about the All-American captain of the lacrosse team? How about the world-class swimmer or diver who's going to the Olympics? How much money do they make compared to Zion? And how about Trey Jones? How about the sixth man on the basketball team or the offensive tackle on the football team? The administrative problems are overwhelming. If you throw the two things together, your sympathies or my sympathies lie with the schools. You cannot allow the athletes to negotiate for salaries and to get NIL. But if you put the salaries to the side, all of a sudden, to me, there's an epiphany. Why not NIL? It's market regulated. It's somebody else's money. It doesn't affect your budget. You don't decide how much anybody makes. Nike decides. Advertisers on Instagram decide. Someone else decides. And this crossed my mind around Christmas of 2018, and I wrote a little article. More important, it crossed the mind of Nancy Skinner, who's in the California legislature, and she proposed a bill And the bill provided that college students attending college in the state of California at a public or a private institution were entitled to their name, image, and likeness, royalties, whatever you want to call them. But they were entitled to monetize their name, image, and likeness, and they could not be declared ineligible by their schools because of their monetization of name, image, and likeness. This, of course, shakes up the NCAA considerably if there are different rules in California than the other 49 states. But to add another level of complexity, 30 states followed the footsteps of California and proposed bills. Let me underscore proposed. 4 have passed. The California bill passed. It does exactly what I just described. The only exception is you can't have a name, image, and likeness deal if it directly conflicts with a contract that the university has with, for example, Nike. But you can have your own deal on anything else. 2 other states passed laws that don't move the needle very much, but Florida passed a different law, which is interesting. Florida's law has what the NCAA likes to call guardrails. Florida's law not only prohibits the kind of contract that would interfere with the university contract, but it prohibits a name, image, and likeness deal, which is in essence illegal recruiting by the university, which is designed to get a high school student or a college student who wants to transfer to attend a particular university by offering him money. This is the famous Tuscaloosa Cadillac dealer story, if you haven't heard it. For years and years, NCAA people talk about how a problem with college sports is that a Tuscaloosa Cadillac dealer could offer a big contract to the best high school quarterback in the United States, and he would attend the University of Alabama because he was getting more money. And this is essentially a hidden salary or a hidden payoff to go, and he is obviously a professional. So Florida prohibits in broad language name, image, likeness, which is actually a recruiting tool. So the other difference between the 2 state laws, which is important, is that the California law is effective in 2023, which is seemingly a long time in this context. The Florida law is effective July 1st, 2021, which is right around the corner. So the NCAA has to do one of 3 things. They have to comply by changing their rules to conform with Florida before the University of Florida and Florida State and the Miami and the rest of them get between a rock and a hard place. Or they have to sue the state of Florida, claiming that the law violates interstate commerce principles, which I can shorten the discussion of that greatly by telling you it's an interesting question. I think the NCAA would lose, but it's not clear at all. And the only third thing, the third thing they could do is they could go to Congress and they could have Congress straighten out the problem. So far, and that's what Professor Hagan is going to talk about and the senators are going to talk about. But so far, what we know from the NCAA is we're working on it. There's been a working group. The working group has submitted a report. The report to the uninitiated suggests that there will be changes, but the changes will include the famous guardrails. The guardrails sound reasonable in one iteration. They sound entirely overreaching and unreasonable in another iteration. Among the guardrails proposed recently in one of the proposals floating around Washington was that if Duke had a contract with Nike, Zion couldn't have a contract with Nike because that would conflict and take some of Duke's money away for the next contract. But he couldn't have a contract with Adidas or Under Armour because how would that look? In other words, the NCAA's proposal would be no shoe deals. So I think it's fair to say that the NCAA is in a scramble. They have to make a decision by January of 2021 because they make their decisions at their national conventions, and that's when the convention occurs. And in fact, that is the announcement from the NCAA. In January 2021, divisions 1, 2, and 3 will separately make new NIL rules. Will they be great for athletes, terrible for athletes, somewhere in between? I don't know. But a wild card is Congress. And I'm going to turn it back to Professor Hagan to introduce the issues, the congressional issues, and the senators.
So there are, I think, is a step before we get to Congress, which is one of the things that is currently pending is the possibility that there will be the commissioners on uniform state laws will come up with a common NIL law to be adopted by each of the states. If they succeed in drafting it and if the states accept it, we could have a version of the Uniform Commercial Code relating to NIL rights for intercollegiate athletes. It is likely that will not happen in the short time frame that Professor Simon has laid out. And so with that in mind, the NCAA, as I said originally, has found itself in the historically ironic position of going to Congress to plead for some kind of federal legislation, and particularly federal legislation aimed at giving them antitrust immunity under whatever terms Congress establishes. Now, so far, the response of Congress, I think, has not been entirely what the NCAA has hoped. So the first legislation was that was proposed was Donna Shalala's legislation, which would have protected the NCAA from antitrust liability related to cartel restrictions on coaches' salaries. It would have aimed at the matter that I talked about initially. We're going to be concerned about the distribution of resources by depressing the currently unregulated level of coaches' salaries, and that would be the quid pro quo for the continued restriction on athlete compensation. Professor Simon and I think, disagree on one point, which is how long the NIL fix will actually operate to quiet the distributional concerns associated with the current challenges to NCAA regulation. I think what we are going to see is continued pressure on antitrust claims that all of the cartel restrictions on compensation are suspect under the antitrust laws, and absent some kind of congressional response, we're going to continue to have a challenge to these current rules, what the NCAA calls the clear line of demarcation between intercollegiate and professional sports. So any response from Congress that doesn't provide a protection, I think, will be simply a short-term fix against a long-term set of challenges by parties claiming under the antitrust laws. There is another element. So the NCAA clearly has now accepted some kind of NIL reform will happen. What the form is clearly open to a lot of doubt. How much it will be there to protect the Zion Williamsons, and how much it will be structured to provide a kind of pooled set of rights for all intercollegiate athletes. And I think that is still open to doubt. And part of the issue here is, as Professor Simon already noted, there's a great deal of concern about the use of NIL type agreements to provide recruiting advantages for one school or another, the level playing field kind of argument. So I think things are very much open. Now, Senator Booker and Senator Murphy wrote a series of reports, social justice grounded reports, talking about what should be the principles that inform reform. And he and Senator Booker and 8 other Democratic senators have now drafted legislation that contains not only NIL rights, but a series of other rights. Rights to continued support and access to their education, enhanced medical protections, enhanced protocols to protect them, protect their safety and health. And this is all happening at exactly the time that NCAA athletics are most under pressure from COVID-related losses of revenue. So the legislation will impose additional costs. Some of these are presumably borne by third parties, but not all of them. And it will impose them at exactly the time that these institutions are already feeling pressure. So we're in an extraordinary moment. The legislation coming out of Senator Booker and Senator Murphy's offices is the most comprehensive set of protections for athletes that we've seen to date. But I want to give Professor Simon a moment to disagree with me or chime in. Except that I have just seen that Senator Booker has now arrived. So I will allow Professor Simon his ironic grin and turn this over to Zach Flegel to introduce Senator Booker and the Athletes' Bill of Rights.
All right, thank you, Professor Hagan and Professor Simon, so much for that wonderful overview of NCAA reform. I now have the privilege to turn it over to the James B. Duke and Benjamin N. Duke, Dean of Duke Law, Carrie Abrams, to introduce one of our 2 distinguished guests for today. Dean Abrams, it's all yours.
Thank you so much, Zach, and good afternoon to everyone. Thank you to our many guests from all corners of the legal and educational communities for tuning into this Duke Law event. As Dean, it's my privilege to welcome all of you to Duke Law School in this new virtual form that we have taken this fall. It's also my honor to introduce one of our esteemed guests for the afternoon, someone whom I have admired from afar for many years. Senator Cory Booker is currently a United States Senator representing the state of New Jersey. He is the former mayor of the city of Newark and most recently a 2020 presidential candidate for the Democratic Party. As the first African-American U.S. Senator from New Jersey, Senator Booker has played integral roles in the passage of legislation, advancing women's rights, affirmative action, same-sex marriage, and criminal justice reform. What many don't know, however, and what is very relevant for our purposes today, is that before beginning his career in politics, Senator Booker was an All-American high school football star. He continued his athletic career at Stanford, where he earned all Pac-10 academic honors. He also attended Oxford University as a Rhodes Scholar and later Yale Law School, where he was an active member of the National Black Law Students Association. In August, Senator Booker, along with Senator Chris Murphy of Connecticut, as you have heard, introduced the framework for a landmark proposal for a new college athletes' Bill of Rights that would expand the rights and opportunities for all college athletes across the country. Senator Booker, thank you very much for being here. We are so grateful to have you join us today at Duke Law.
All right, Senator Booker should be joining us in just a moment. While we wait, I guess I can dive deep into a few different things that those who are interested in this debate or this conversation should potential resources you should be on the lookout for. The first is the Harvard Sports Law Journal just had a special edition journal that included multiple essays and different perspectives on this issue. So I highly recommend everyone to check out Harvard Law's new sports law specific journal, special edition related to NCAA reform. Another great resource that I'd highly recommend is Professor Gabe Feldman's podcast, the Between the Lines. You can find it on Spotify. For those of you who don't know Professor Feldman, he is a Duke Law alum. I think he's like a double or triple Dookie. And he's now the director of sports law at Tulane Law School. And he's dig deep into the NCAA reform conversation on his Between the Lines podcast, and actually has hosted Jay Billis and Dee Smith, who our show has also will be getting as well. Other resources that might be of interest to many of you viewers are the Knight Commission videos. The Knight Commission is doing a new webinar series about, looks like we have Senator Booker. Senator Booker, welcome to the future of college sports. So great to have you.
It is so good to be on. So good to be on. Sorry I'm running a little late, but I'm excited to connect.
Absolutely no problem. Senator Booker, thank you so much for taking time out of your busy day. I know this is an election year. This is a lot of crazy stuff going on, but we appreciate your time.
I'm grateful for you all. I'm grateful for your activism, David, and leadership in this space. It's extraordinary. It gives me a lot of hope that issues we've been dealing with since I was playing ball back in the 90s that we actually might be able to address. So thank you so much.
Well, given the time restraint, we're going to jump right into the conversation if you don't mind. Like we've been talking about, 2020 has been a crazy year. There's been a lot of unprecedented things that have happened historically, globally, especially in our country. However, you've been able to center yourself around this particular issue and kind of focus on athletes' rights in college sports. Why is this legislation in particular important to you? And what does your proposal do about the issues you identify?
Well, look, I am where I am because of sports and specifically because of football. I was, a scholarship athlete at Stanford, and what I learned in that experience is just invaluable. I am where I am, even in the United States Senate. I credit having that as a part of such a fundamental part of my foundation. But, when I played, too many of my classmates and my teammates, I just saw things that were just plain wrong. And especially in those sports that are just overrepresented with African Americans, I saw a lot of things to me that just smacked of outright exploitation in those incredible revenue generating sports. And especially because in the years since I played, I just saw a lot of just really things that were patently unfair. Institutions making millions of dollars off of the artistry and athleticism of these athletes, but then those athletes being struggling with everything from medical bills to having not received a fair shot at an education. And so I know that right now we are at a pointed moment because, as I think was said earlier in the conversation, is that we have this great opportunity that's being presented because of the activism within individual states around name, image, and likeness, that the NCAA is actually coming to Congress and asking for them to help them out. And I think this creates a tremendous opportunity for us to actually pursue justice for athletes, to end exploitation, and to create more fairness and more opportunities for college athletes. And that's why we really felt it was important to get a basic fundamental Bill of Rights for college athletes, amounts to really just a bill of fairness that really ends exploitation and affirms to them the basic rights that they should be afforded, that they should have been afforded even decades ago.
That's fantastic, Senator Booker. And I'd like to move into a discussion specifically about your proposal, maybe from a broader perspective. So in June of this year, as you probably well know, your alma mater, Stanford University, announced its decision to cut 11 varsity sports, including field hockey, wrestling, and rowing. And it did so because the university determined that these sports were no longer financially sustainable. And it's worth noting that these deliberations happened before COVID-19. And Stanford's not alone in this trend. As you know, several other schools have also cut a variety of varsity sports. And so before I jump into this question, now that Senator Murphy is here, I'd like to introduce Senator Murphy. Senator Murphy, thank you so much for joining us. Senator Chris Murphy, since 2013, has served as the junior senator from Connecticut. Among Senator Murphy's priorities in Congress, as a member of the Health, Education, Labor, and Pensions Committee, which is known as HELP, where he's worked to make college more affordable and ensure that our public education system works to serve all students. Under this priority, Senator Murphy has been perhaps one of the strongest voices for college athletics and athletes among all policymakers. And he's released a series of 3 reports, as we had just discussed, entitled Madness, Inc., that focused on the issues that we'll be discussing today. Prior to his time in Congress, Senator Murphy attended Williams College and University of Connecticut School of Law. So, Senator Murphy, thank you so much for joining.
Great. Thanks so much for having me. Look forward to the discussion. And hey, Corey.
Hey, what's up, Chris?
So I'll jump back into the question that I was about to ask. And this revolves around Senator Booker, as I mentioned, with Stanford, your alma mater, cutting different sports. Does this emerging trend of cuts to so-called non-revenue sports concern either of you? And how would you expect your proposal to affect the financial viability of these sports moving forward?
Chris, I'm going to yield to you. Go ahead.
Well, I mean, listen, I sort of think this is a bit of a red herring. It certainly concerns us, right? We want to make sure that there is a robust array of sports available for college athletes. I didn't have the sporting success that Corey did in my athletic endeavors. I tried out for my college tennis team and did not make it. But I frankly would have probably paid money to play college sports. It was that important to me, and I gained so much from my time as a student athlete. And so I want to make sure that everything we do here make sure that all of these options are available to both men and women on campus. But let's be clear. At Division III schools in which none of these programs make money, they have a broad array of sports available on both sides of the ledger for men and women. In high schools where sports make no money, they make sure to have all of these options available. Why? Because they think it's a really good tool to use in tandem with education to grow students, to grow their minds, to grow their ability to work with others. And so, this idea that if schools can't make as much money as they are today off of football and basketball, that they are then going to punish their students by ending athletic programs doesn't square with the fact that the majority of colleges in this country make no money off of any of their athletic programs and still choose to invest in college athletics. And there's really no reason why my alma mater, Williams College, could find a way to make those sports available. But a massive state institution with 10 times as much revenue couldn't find a way to do the same. It might mean that sports end up being a little bit less professional looking than they are in order to sort of afford the full panoply of sports, but it doesn't mean that it's impossible. And I do think that this is a bit of a straw man argument used by the NCAA and many schools to try to make us scared of the slight redistribution of wealth within college athletics that we're arguing for.
Shifting gears a little bit, I'd like to discuss what we call the revenue sports, which are men's football and basketball. Many advocates for NCAA reform have framed this issue such that student athletes should be able to get the same type of opportunities that any other students on campus, like me and David, are afforded. One buzzword that we've heard constantly around this conversation has been the word guardrails. In other words, regulatory restrictions, which would limit the student athletes from pursuing certain types of arrangements. Let me give you an example, alcohol sponsorships. So regular students like myself are allowed to be sponsored by beer companies. And in fact, just this week, I've actually been sponsored by my first beer company on Instagram. So yet, even among the 5 state laws already passed, Senator Booker, your home state of New Jersey's new NIL law addressing these issues includes some of these types of guardrails. So my question more broadly for you, Senator Booker first, and then Senator Murphy, if you want to chime in, do you believe in a more free market system, or should there be some type of guardrail restrictions in place?
Look, there should be some types of reasonable restrictions on what types of endorsement deals that folks can enter into, but the restrictions, need to be in a way that's just not too far restricted. I can imagine, again, sort of having, let's call it a dual federalism that allows sort of each state to determine what types of deals athletes are able to enter into, because look, what's considered, taboo in like a state of Mississippi might not be considered what's taboo for the state of California, for example, or the state of New Jersey. And so, look, I envision us making sure that athletes and universities are being held to a similar standard. So that if athletes can't enter into certain specific types of endorsement deals, the university should not be able to enter into those deals as well. The reality is, and this goes through a lot of what Chris and I and others are really saying, is what we have is a system where we often say certain things are okay for coaches, but they're not okay for the athletes. And that goes down to just eligibility requirements and the ability to transfer, for example. I remember very specifically a coach recruiting me at one school, and then he gets bumped to another school and starts recruiting me all over again within the same recruitment period. But we know that athletes don't have the same ability to transfer. So this idea that what's good for the university, their coaches and other things, is not good for athletes is really problematic to me. But as far as general guardrails, yeah, we should have some general guardrails as well.
I would just add one piece because I agree with everything Corey said. It's also a question of who sets the guardrails, right? So the NCAA would like the ability to set the guardrails on their own, right? They've essentially asked Congress to grant them the authority to decide what endorsement deals students can do and what they can't. To me, that's unacceptable. I mean, I know the game the NCAA wants to play, which is to use those restrictions to essentially render the right unavailable to students. And so in our Bill of Rights that Corey led on and many of us contributed to, we made clear that, ultimately this can't be just shoved into the hands of the NCAA, that if there is going to be a set of guidelines, a set of guardrails or a set of rules, that it's got to be done through a process in which students have fair and adequate representation.
And Chris, and maybe you and I want to comment a little bit further on this. I mean, this goes to the fundamental idea of what is exploitation, right? It's when our athletes have no voice, no influence whatsoever around controlling their own destiny, controlling or benefiting from their worth. And it's really frustrating for me that we have a system right now where you have these young adults who are really stripped of their ability to influence these decisions that are being made by folks who are profiting into exorbitant amounts off of them. And this idea of a voice, to me, and a lot of the athletes, I was talking to some Pac-12 athletes who, they're being controlled on what they can even say on their Twitter accounts and being punished for even just expressing ideals of free speech in ways that to me are outrageous. And so I'm really grateful to have Chris as a partner in this, because I think he and I believe in this fundamental governing value, which is that you have to have players at the table when the decisions are being made. And if they're not, then that whatever system you set up, then this generations long exploitation of college athletes will continue.
Thank you both so much for your thoughts on that. And I kind of want to go in that same vein and address this idea that you've talked about exploitation of athletes. I know, Senator Murphy, you've kind of referred to this as a civil rights issue. And I'm curious as why you believe this is particularly a civil rights issue as opposed to maybe an antitrust or a labor law issue.
Well, thanks for the question, David. Listen, I think, anytime there is a broad class of Americans who are being denied a right to adequate compensation, that is an issue of rights. Maybe in some cases it's an issue of economic rights, but in this case it's an issue of civil rights and racial justice, because you cannot escape the fact that when you are looking at those who profit, who are by and large white coaches, white athletic directors, white sports industry CEOs, and those who are providing the labor, at least at the Power 5 schools, the basketball and football programs, that are being denied compensation, they are by and large African-American males. And so I just don't see how you can escape viewing this as a civil rights issue. And I think we have to frame it that way. And Corey is right. Without trying to cast general or specific aspersions, the NCAA and many of their members simply don't believe that these students have a right to a voice, right? They really do believe that they should be happy with this relatively meager amount of compensation, the athletic scholarship, and shut up. I mean, that's essentially their view, that that's good enough. Don't pay attention to how much money we're all making behind the curtain, and stop complaining. We would never allow for that in any other industry. And I can't help but think that we have allowed for it in the college sports industry because of the dichotomy between the race of those that are making the money and the race by and large of the athletes who are putting the product on the field.
And for you, Senator Booker, I'm curious to hear what you mean when you say athletes' voices. I'm curious to see if you believe that they should be protected, their voices themselves, when they decide to raise their voice against social injustice, whether that's from a societal standpoint or even from their coaches themselves. And what can we do legislatively to protect those voices?
So look, I'm particularly charged up right now because of the stories I've been hearing from sort of athletes, current college athletes, who at a time where they know that this is a nation that will view them differently. I will never forget in my years that my interactions with police. I remember that being pulled over once where I was terrified, and it was literally my varsity jacket in the back where the guy noticed it and then suddenly changed his tone towards me. But we know we are living in a nation where African Americans are treated by the whole justice system in a way that is statistically provable, that is so rife with injustice. And then when you come to the fact of the peril to your lot, to Black bodies, this is one of the main issues of justice in our country right now. And so here you have these athletes that have the attention of millions and millions of Americans, and you are seeking to silence them. And that action of silencing them, frankly, is an action that preserves the status quo. To me, that is a level of complicity with an unjust system that is unacceptable to me. And so here are athletes at a time in their lives, and I don't mean to be in any way, so many of our athletes have a potential to go into anything, but I know from a lot of my classmates, many of them, this will be the height of their moment of attention where they are getting the most focus. And for them not to be able to use that in a way that is an affirmation of free speech is really offensive, I think, to Chris's sort of core sense of justice. And the stories that I've heard over the last few months, straight from college athletes about what their coaches are doing to them when they try to speak out, is frightening. And we know the pressure on athletes. This is why I have such respect for a lot of the college athletes I'm meeting, is because I know what it means to be on the cusp when you're competing for a position, and the opinion of a coach could make a subjective decision based upon the future of your career. So that's why this tradition of athletes in America, from Muhammad Ali to Arthur Ashe, I can go through a lot of the athletes that were willing, Martina Navratilova, for example, her just coming out as an athlete cost her a significant amount of money in her time. I know the courage we've seen in athleticism. So that is a real big issue for me. And this is, again, why I'm so appreciative of the team of us in the Senate, that we do believe that this should be at the table. We do believe the preservation of rights should be allowed. And so our legislation really calls for college athletes to be at the table, to have power in negotiating and the ability to protect their fundamental rights and assert themselves for what it's worth. And it's hard for me when I have real stories of experiences that I had, and I'll never forget a guy I played with who was the center of so much of the media attention, and our team using him as a poster child, quite literally, the wealth that he helped to generate. He did not go on with a successful NFL career, but yet his earning years were so much, probably his peak earning years were his time at college football. And he was stripped of that power and that money and that opportunity. And to think that's compounded by stripping your freedom to get an education, because we know if you play ball, you're spending 40, 50, 60, 70 hours a week. You compound that many of us have health injuries that affect you for the rest of your lives, expenses on that. I could keep going through all the things that to me are just simply unjust. So I just, again, Chris and I keep coming back to this idea of ending exploitation and giving the kind of power for people to control their own destinies, to be able to assert their own voices, especially at critical times in American history, like we're in right now, where there seems to be a racial awakening. We should call out directly the civil rights issues, as Chris did so eloquently, that are clearly going on within major college athletics, but also the ability for these incredible gifted athletes to use their position to advance larger issues of social justice.
Senator Booker, Senator Murphy, thank you so much for your candidness on these issues. I know that these are a lot of things. There's a lot going on in our country right now, and I appreciate you spending the time with us to talk about this. So in this moment, I'm going to move on to about 15 minutes worth of questioning from former student athletes themselves, who are now Duke Law students, Caitlin Ray, Samson Goriola, and Hayes Rule. Caitlin, you're up first.
And I hope Caitlin might have one or two questions about Chris's tennis career, because I learned a lot right now, and I'd like to hear more about that, Caitlin. If we can pull that out, it might give me the ability, to tease him on the Senate floor. So I would appreciate that.
I was going to say Murphy was being too modest, because their women's tennis program is quite famous in the tennis world. In fact, our coach got hired at USC, and she's tremendous. But Senator Booker, Senator Murphy, thank you for being here. Thank you for your work. Hi, everyone. My name is Caitlin Ray. I'm a 3L here at Duke Law School and former tennis player at UCLA. And I'm particularly interested in the tensions between the intensity of being a college athlete, those 40 to 70 hours you just mentioned, and academic rigor, and how we can restore academic legitimacy to the experience. And so how will maximizing academics be manifested in the College Athlete Bill of Rights? And then kind of thinking longer term about the structure of the system. What is your take on a model where, of course, allowing NIL compensation, but where athletics would be sequenced first, where they would focus only on sports, followed by purely student years once eligibility ends? In your opinion, is separating the activities in time even a workable model?
Chris, go ahead.
Yeah, sure. Yeah, I will say that my freshman year at Williams, very small Division III college, they did win the men's national championship in tennis. So I was probably not going to compete on that team in any year, but they were particularly good the year that they decided to not let me join. Yeah, Caitlin, thanks for the question. I mean, this is so important. And let me say at the outset that the reason that Corey and I and others came together to frame this as a Bill of Rights is because while many would like Congress to simply deal with this issue of name, image, and likeness, because it is a legitimate issue that should probably be best solved at the federal level if there's a whole bunch of different state laws that contradict each other. We believe that if Congress is going to weigh in on the issue of college athletics, then we need to do it in a comprehensive way. And we shouldn't just step in and do a favor for the college athletic programs who are worried about contradictory NIL statutes. And so we put together this sort of list of, whatever you want to call them, priorities, demands that need to be included in this bill, because we recognize you've got to go far beyond just the compensation of a handful of top athletes who maybe can make these endorsement deals. And as you mentioned, as Corey mentioned, you are talking about a reality in which college athletes, frankly, some even, outside of the Division I level, are spending just inordinate amounts of their week on sports, and academics comes second. There are also other ways that plays out. We have plenty of evidence of college athletes sort of being pushed in to majors, pushed into programming that might not be best for them if they are going to have a future that doesn't involve professional athletics, but is best for the athletic program because they're the classes that comport best with the maximum amount of time being spent on athletics. And then lastly, I think about it from UConn's standpoint. So, University of Connecticut, used to be in the Big East Conference, which made a lot of sense for us. It didn't require our athletes to, travel extraordinary distances in order to play games. But then when we got into the business of chasing big time football, we ended up getting into a conference that we are in the process of finally dislodging from that required all of our athletic teams to travel regularly to Texas and to Florida, to Oklahoma, to very long distances that took time away from academics. So yes, I think at the heart of this has to be not just the admission that if you are going to act like a professional athlete, spend all of this time on athletics, be required to travel like a professional athlete, you should probably be compensated for it. But we also have to have a metric here, a much stronger metric than exists today, that accurately tracks graduation rates, performance rates, and says to schools, if you can't measure up to these standards, then you don't deserve to be running these programs. And as we know, those standards that exist today are, such a low bar that it's so easy for programs to step over. And the way, for instance, that graduation rates are tracked today don't accurately reflect the actual success of these programs. That's got to be a big part of the reforms.
And if I could just add, Caitlin, so most college students don't graduate in 4 years. And so as Chris was just saying, I mean, to put a full-time job plus on top of that, and anybody who's played competitive sports knows, like I was doing sit-ups in my room, literally, I was always inspired by Bruce Lee, and he was always doing, flipping decks of cards and stuff like that. We do insane things when we're pursuing our sports. So to Chris and I, it's absurd to think that this idea that you're going to graduate in 4 years. And we believe that there should be lifetime scholarships allowed where people can come back. And the other point that Chris made that I just want to just doubly highlight is this idea that accountability, fundamental to accountability, is transparency. And I know all kind of games that are played to try to obscure the demands that are on college athletes by coaches, so that they are comporting within the limitations that are there right now. So having more transparency and a better system of accountability to really see what's happening to a college athlete, to me, is just critical.
Thank you both for your insights. I really appreciate it.
Great question, Caitlin. Thank you for joining us today, Senator Booker, Senator Murphy. My name is Samson Goriola. I'm a current 2L at Duke Law School, and I formerly played college football
Hey,
Whittier
Samson,
College.
I'm sorry to interrupt you, Samson, but that's like a lot of pressure. If you're playing football and your name is Samson, you're not putting up a lot of weight, man. I mean, I would have had fun teasing you in the weight room, man.
Luckily for me, I held my own. I tried. Senators, could you discuss how this bill would apply to those students who end up transitioning away from the student athlete status? Specifically, would this bill provide any support to these walk-away athletes dealing with the mental and physical after effects of collegiate play?
Yeah,
I mean,
go ahead, Chris. Go ahead,
no,
Chris.
I'll just start. Yeah, in a myriad of ways, this bill affects that population you're talking about, because that's who we're thinking about. We're thinking first and foremost about the 99% of college athletes who are not going to make their retirement fund off of professional athletic exploits. And so, as Corey already mentioned, part of this proposal is to have guaranteed scholarships, right? You show up, and if that school wants you bad enough, then they should make sure that they're going to guarantee you those 4 years. Second, the ability to move from one school to another without penalty. If you don't feel like the academic environment or the athletic environment is right for you, you shouldn't be penalized because you choose to bring your education or your athletic experience somewhere else. Third, everybody should be covered by healthcare. If you're playing big time college sports, you shouldn't have to go scrape together the dollars to treat your injuries. And then lastly, and I'll end here and then let Corey expand, we see compensation as a partial mechanism to try to address what are often these lifelong injuries. I think it's going to be a while before, especially in the football space, we truly understand the risk that athletes are putting themselves in who play through college. But at the very least, if we find a mechanism to compensate college athletes, there's some money there that might be able to remedy or address any long-term health concerns. And so, to me, that's one of the great injustices, is that all of this money, $14 billion, is being made in a sport, especially the sport of football, in which there's real significant risk for injury, and none of that money right now, none of that money is going to create any kind of fund to compensate these athletes in the long run.
Yeah, Chris covered that. That's excellent.
Thank you very much, Senators.
Good afternoon, Senators, and thank you so much for joining us today. My name is Hayes Rule, and I'm a second-year law student at Florida State University College of Law. Before law school, I played Division I men's golf at Mercer University in Macon, Georgia. You've already spoken a lot about the need for athletes to have a voice. Does your bill recognize a right for student athletes to form a union, both to collectively bargain and or to regulate agents who seek to recruit athletes for endorsement deals?
Chris, go ahead.
Well, just to sort of be clear where we are right now, we are sort of working on drafting legislation, but what we actually released is sort of a framework, an outline. We sort of refer to it as a Bill of Rights, but the idea is that eventually becomes part of legislation. Our Bill of Rights is sort of silent on this issue of union organization. I will sort of just speak for myself. I think it's paramount that we make clear that students need to be able to bind together in order to negotiate these rights. It's a complicated issue that I think we are learning more about right now. And so Corey and I and a handful of other colleagues, including Sherrod Brown of Ohio, who works very closely in the space of labor organizing, have been talking about what the right move is. But I think as we envision a student voice, the NCAA would love it if all of those voices were independent, having to compete for space. So I think in whatever form it is, whether it be something that looks more akin to a traditional union, or whether it's something different, maybe even a new kind of model that we create to allow for student voices combined, somehow or some way, we're going to have to make sure that there's an ability for students to speak as collectively as they wish without the restraint of law.
And I'll just add to that, I think that's one of the reasons why you have union leaders who've endorsed this proposal, our Bill of Rights. It's just this understanding that right now, athletes have no ability to organize or to use their collective power. And that's something that's really missing through all of this. So I'm encouraged. And again, I think that Chris has shown what I think we all have, which is this sense of humility before athletes right now, that we are still learning and trying to put forward as senators what best represents the athletes that we represent in Congress. So I just agree with what Chris was saying. What I don't agree with, Hayes, is that hair you have on your head that just defies gravity. That makes me very jealous, man. I mean, that's like flaunting. You're lucky you're not a New Jersey constituent. I might have to ask you to cut that.
What can I say? I wake up like this. I don't know. It just happens.
You kept it for a couple of years after your college athletic days, so it didn't immediately abandon you.
No, it did not. It didn't retreat until a few more years later.
Oh, awesome. Well, thank you both, and I'll turn it back to Zach and David to close us out now.
All right, thanks, Hayes, and thank you again, Senator Booker and Senator Murphy, for joining us today. We've reached almost a conclusion of our event, and I wanted to be able to give you both the final 5 minutes or so to provide closing remarks to this conversation and where you see the future of college sports going in the future.
Well, I'm going to let Chris have the final word, and I'm going to eat up a few seconds. So first, and just want to say thank you to the organizers of this event. Chris and I think both really are appreciative of the energy and the sort of the work that's being done. I don't think that he and I would be in a position to try to influence this legislatively if it wasn't for the activism across this country and in many different states. I think that this is a moment of opportunity. It's not a moment of certainty. In other words, I think that there is a lot of opportunity to do good here and end what I think has been nightmarish exploitation of college athletes for decades and decades. We have the chance to end it, but there's a lot of work to do between now and then. So for folks that agree with Senator Murphy, myself, and the other senators that are working, or for those that have even led us to this moment of opportunity, the best I can do is say thank you for your work, but encourage you to continue the fight, to continue the struggle, because that's what's necessary for us to make progress. I am really hopeful that after this election, there may be an alignment of an opportunity to get something great done, but that's just not going to happen unless people really lean in and continue to work. So thank you, and Senator Murphy can close us out.
Well, let me just add my thanks and add mine also to Senator Booker, who's been a great partner in all of this. There's no other industry in America of this size with this kind of injustice inside it for workers. There's no other $14 billion industry in which we allow employers to form a cabal in which they limit the wages and earnings of those who are actually providing the talent. And why we allow it to occur in college athletics is beyond me, but Corey is right. This is a crisis with an opportunity. And we know that ultimately we can't lead on this issue unless we have you by our side. And so while it's so important for you to step up and assert your own voice, it is also important for us to remind you that we're learning. I might be learning a little bit. I might need to learn a little bit more than Corey does because I didn't, get the experience myself. But I think both of us really want to be in a constant dialogue with you so that we're accurately representing where the voice of sort of recent college athletes and present college athletes are. And then finally, to sort of add to the hopefulness of this moment, you're talking to two Democrats today, but Corey and I spend a lot of time talking to our Republican colleagues. And every issue these days has a sort of a bit of partisanship at the very least to it. This one has less than others, and I remain hopeful that we're going to be able to find Republican partners in this effort as we head into 2021. So stay tuned and stay in touch. Thank you so much for your leadership and for allowing us to be part of this today.
Yeah, and thank you both so much again for being here and for your final words of wisdom. And thank you everyone for tuning in this afternoon. We hope everyone has a great weekend, and we'll hopefully see you next Tuesday for a conversation with D. Smith.